All right, welcome back. Yes, indeed. We're talking about some of the court cases that are coming through from Rivers State. So we've got two gentlemen joining us this morning to weigh in on the subject matter. Rufus Godwin is a legal practitioner and former head of civil service for Rivers State. He's here with us in the studios. We also do have joining us virtually Henry Ekene, who is National Legal Advisor, the Committee for the Defense of Human Rights, CDHR. He's also a legal practitioner. Gentlemen, good morning and thank you for joining us on the program today.
Thank you for having me. It's my pleasure to be with you this morning.
Okay, so Mr. Godwin, before people said Jack Robinson, after the judgment in favor of the Martin Amiule-led Rivers State House of Assembly, another judgment came through, barring the chief judge and others from dealing with Martin Amiule and 26 others. So this is confusing for several people. They keep wondering, they don't even know what to do. So if several people are confused, but the governor doesn't seem confused about it. So the other group went ahead and screened the nominee. He then said, look, this is the legitimate group. So from the point of law, what is the implication of that judgment, the latest one?
First and foremost, I want to say for the records that Amiule, even by the judgment you just referred to, is the Speaker of the Rivers State House of Assembly. If he never was, the judgment of the Court of Appeal delivered on Thursday last week has settled that and put that to rest.
The Rivers State High Court judgment,
the Court of Appeal,
the Chief Judge.
No, I'm coming to that.
That's what I'm talking about.
The Court of Appeal judgment, because you refer to Amiule as the Amiule-led faction of the House of Assembly.
Is it not leading the group?
Amiule is the Speaker
Who is the
of the Rivers State House of Assembly.
Is the Speaker not the leader of the group?
It's the Amiule-led faction.
Is the Speaker not a leader?
He's not leading
of
the
group?
faction. He's leading the House of Assembly of Rivers State.
I didn't say faction. I said group.
I'm glad you noted that correction.
No, I didn't say, there was no correction.
Okay.
I didn't say faction.
So let us acknowledge that Amiule, Right Honorable Martin Chike Amiule, is the Honorable Speaker of the Rivers State House of Assembly. That has been confirmed by the Court of Appeal judgment delivered last Thursday, 4th of July. We proceed from there. What happened, which you just referred to, is the most egregious affront I've ever seen in my almost 40 years as a lawyer. That the Court of Appeal, in its appellate jurisdiction, delivered a judgment where he has slammed and indeed fell short of casting strictures on the High Court of Rivers State for assuming jurisdiction on a matter that is exclusively vested in the Federal High Court, and said, look, you have no jurisdiction. Therefore, the orders, the ex parte order you met, they were a nullity. It's elementary, even for a rookie lawyer. And I said this on air. Jurisdiction is the bedrock, is the concrete foundation of judicial adjudication. If you don't have it, you labor in vain. The trial court of High Court of Rivers State, Justice Charles Wali, labored in vain when he assumed jurisdiction and the matter exclusively vested in the Federal High Court. And the Court of Appeal has said so. So I'm quoting an extant substituting judgment of a higher court now.
Okay.
Now, that has not been done. That's what I've been instructive enough. Then a brother judge, Justice Stevens, just yesterday, again, did the same thing. He clothed himself with a garment of jurisdiction that he never had. And with such effrontery, ordered the chief judge, please don't receive anything from the House of Assembly. Can he do that? Is it not instructive for him to have learned that Court of Appeal has already fell short of rebuking my learned brother of the High Court for venturing into this matter? Okay. So I will say in one word, it's a clear act of contempt.
Okay.
Which is punishable under Section 133 of the Criminal Code of Rivers State.
Let's get his opening view as well. Mr. Ekine, you heard him speak about two things: the leadership of the Rivers State House of Assembly and the judgment yesterday. What do you say?
Yes, thank you. First, the leadership of the Rivers State House of Assembly is not anything that would draw from elsewhere other than the Constitution of the Federal Republic of Nigeria. I subscribe to the fact that it's only one House of Assembly we have in Rivers, the one established under Section 90 of the Constitution. So we can't have two. At best, we will have contenders to that office that the Constitution pursuant to Section 92, requiring that members of the House shall elect the Speaker amongst themselves. So we do have a Speaker of the Rivers State House of Assembly. And I, for me, in the review of objectively of the incidents of, if you like, the former members of the Rivers House of Assembly. That's what I hold. And then that's because when Martin Ameghule and about 31 others together, they were 32, were inaugurated as members of the Rivers State House of Assembly in June of 2023. Nobody had any contention. Then we lost one, and then they remained 31. It is a fact, and I know that my senior colleague in the studio will allude to this, that it is a fact that they had proceedings until the 11th of December 2023 on the floor of the Rivers State House of Assembly. It's a proceeding that even the courts are expected to have judicial notice of, let alone lawyers, even the guests, even the media. Your platform has notice of that proceeding of 11. I have watched that your correspondence channels covered that proceeding of 11th December 2023, where Martin Ameghule read out the letter of the deputy speaker precisely. Before he read that letter, he had actually said that the other members had written to him.
Yeah, ma'am.
About their defection. No, I'm coming. Aleni Foundation, Chamberlain. I'm sorry.
Okay.
I'll be quick about it. That they had ceased to be members of the political party that sponsored them. Then you go to the Constitution, which my colleague there in the studio also would hold to the fact that every citizen has the right to protect it. Even him in speaking.
Okay,
to
I get your point, but I'm asking, from the point of law, considering that judgment that was handed down in their favor, yes, the Okojombo group said they're going to appeal the matter. So are they going to be referred to as the authentic group insofar as the appeal subsists?
Chamberlain, except of time. Otherwise, if I lay my foundation, the answer is very clear to it. Because the Court of Appeal didn't say, didn't discuss, didn't handle, it wasn't before it. The question as to the defection and ceasing to be a member of the Rivers State House of Assembly, that wasn't what was before the Court of Appeal. And everybody said, I was laying this foundation deliberately. So I will get to the point where Victor Okojombo was elected the Speaker of the Rivers State House of Assembly. It wasn't the first person that was elected after Martin Ameghule and his members or his friends defected. It wasn't. So there was a situation that existed. In fact, he became Speaker after Edison Ehie was elected Speaker. So when Martin Ameghule and his colleagues left the House, he never was the Speaker. I mean, Victor Okojombo. It was Edison Ehie that was elected. Okay. And he gave effect to Section 109, subsection 1, paragraph G, pursuant to subsection 2. He gave effect to the defection by declaring those seats vacant.
Tell us, give us your opinion then about the judgment that was handed down yesterday. Because he also did say here that that judgment is of no consequence because, I mean, the preceding judgment is a higher court, and so this court cannot take precedence over that one.
Chamberlain, you see, I know that the question of jurisdiction here is not a blanket. It doesn't cover the entire thing. You consider it also considering the subject for the court. It is not a general situation that the state high court cannot entertain any matter if the provided parties have probably another matter. You cannot import the subject in another matter into another matter. The question that would be here is, what did they go to court for? Section 272 sub 3 that the Court of Appeal relied on to hold that the High Court of Rivers State, presided over by CN1,
tell us,
never had jurisdiction. It's different.
What did they go to court
from
for?
This particular decision of yesterday.
What did they go to court to stop the impeachment of the governor?
Yes, that's part of what they are playing.
Okay,
so they didn't go to court for declaration of the defected members to declare their seats vacant. No. Okay. It is when you go to court to seek the court to declare a seat vacant that you have to go to the Federal High Court. You can actually go to court against members of the House of Assembly for a different subject matter.
Okay.
You can go to court for against any person who is impersonating the members of the House of Assembly. It's a different matter. It's not a question that the Federal High Court has exclusive jurisdiction with respect to the provision of 272 subsection 3.
All right, let's get Mr. Rufus on that, because one of the issues that came up, especially from that court judgment on Thursday, first of all, let's start from there, was that this ruling that we heard from the court was on jurisdiction. It had nothing to do with who's going to be the speaker or who's going to be having, who the lawmakers representing the people of Rivers State are going to be. Everyone kind of understood that this was strictly based on jurisdiction. What do you make of that assertion? Because based on everything that's happened, you've basically interpreted that to mean that they should come back and they are the legitimate members of the State Assembly.
Jurisdiction of a court is not invoked in the abstract. It must cover a subject matter. And what is the subject matter here? It is the subject matter that determines whether a court has jurisdiction or it doesn't have. That takes us to what they went to court to seek. They are asking for declaration that Okojumbo is the legitimate and substantive speaker of the 10th Assembly of the Rivers State Assembly. That's the first declaratory relief that Okojumbo and his team sought before the High Court. And then a declaration that with effect from 13 December, the 1st to the 25th defendants lack the competence to purport to function. That is Right Honorable Martin Chika Ameule as the Speaker and the other members of the House. Those are those they are challenging. Now, this is one instance in history when the baby and the bathwater go. If the Court of Appeal in its wisdom said, look, if the State High Court, you are not supposed to be hungry for jurisdiction. That's a principle of law. Courts are not hungry for jurisdiction. You wait and see that the right subject matter comes before you, initiated by due process in accordance with the law. You don't go searching for the jurisdiction, ferreting everywhere like a sentry. That's what the Rivers State High Court did, presided over by Justice Charles Wale. The Court of Appeal said, no, you did not have jurisdiction. Having said so, what will happen? It struck out. And then he made an order, and that is the gravamen of that judgment. He said parties are to return to status quo ante bellum. What does that mean? It's sad that in Nigeria, professional issues are taken over by those who are ill-prepared or have one understanding of it. Everybody now joins the fray.
What about what Mr. Kine thinks about the judgment that was handed down yesterday?
It's completely wrong. I'm coming to that. The Court of Appeal said parties return to status quo ante bellum. In Ojuku against the military governor of Lagos State, the Supreme Court defined what is status quo ante bellum. That is the status, the state of affairs, the situation where you were before the legal battle started. So I should ask you here, rhetorically, what was the status before Kojumbo and his colleagues, who were suspended members of the House, went to court? It was that Right Honorable Martin Chike Amewule and his colleagues were lawful members of the House under his leadership as the Speaker. That was the position, the state of affairs. That was the status. That status was what Okojumbo sought unsuccessfully to derail. And the Court of Appeal said no.
I'm going to get you to talk about.
We're
going to talk about what happened yesterday.
What happened yesterday was an affront. Because I
know you want to respond to that.
Yes.
But let's talk a little bit about Rivers State in itself and what all of this is doing to governance in the state. It's such a fragile situation. Doesn't look like a solution is going to come out of real soon. Two houses are sitting. And this one is swearing in a commissioner. This one is saying you have to represent the budget. Talk to us about governance. In your view, how has this affected governance in the place?
I can speak on this authoritatively because I have been in government almost my entire working life. I joined the government as a law officer, became the Solicitor General of the state, and ended up as head of service of the civil service of Rivers State.
Does it worry you? Does it worry you? Does this situation worry you?
That is why we're here. And the only way you can see clearly the absurdity that this constitutes is to take a flashback to the last 8 years in Rivers State. The last 8 years was the years of boom, the years of prosperity, the years of governance. Did we have any incident like this? All the development agenda was carried out. Then we have less than a year after that 8 years of prosperity, of good governance, of unity, of a political family. What we're having now makes all of us shudder. And we are all embarrassed and scandalized. Why is this going on? And so we are concerned. That is why we are here to set the record straight. And then the way to go about it is to sound an alarm that those who are politicizing the judiciary through these matters are creating judicial anarchy for us. The High Court should have advised itself, no, I can't hear this matter. Justice Stevens of the Rivers State High Court should have advised himself, I can't hear this matter.
Why?
Because the Court of Appeal has just delivered a judgment where it said the High Court has no jurisdiction on this matter. Well, forget about what the coloration my Lennon friend is trying to give it to say, oh, what went to court yesterday is a different thing.
Is it not entitled to his view? Is this the same way you're giving yours?
No. I'm rejoining. I'm rejoining this issue.
But you think we should forget about his?
No. That view is erroneous.
What? So yours is not?
Mine is the correct view.
Mr. Kine, what say you?
Chamberlain and Taylor, you see, a former permanent secretary, when I discuss, I don't discuss personalities, but professionally, I think I should make reference to a senior. I would imagine that he would have told us, and even the public, those who are viewed, including you, what the subject in this suit for yesterday was. Yeah. And let me ask a simple question. This is rhetorical. I don't expect him to answer. I have said here, the fact that we have this debacle in Rivers State that unnecessarily was created and for a purpose on the 11th of December, it doesn't mean that every other suit that is filed, even if you have the Rivers State House of Assembly or those individuals in that suit, that it all means about the question of defection and vacation. No. So the matters that deal with defection and vacation, we should let those matters go on, which are in the Federal High Court.
Okay, well, Mr. Kine, we'll try and get that connection back to you. But
that inures to me as a benefit, so I can take advantage.
No, I think we got him back.
Chamberlain, I'm still here.
Go ahead,
please. Here, Chamberlain, please. Yes, I know the one that is before the Federal High Court by civil society organizations. That is where they are talking about the issue of defection and vacation. Also, the one by a political party in that Federal High Court. And let me say again, known to even Mr. Godwin's there, that the one that Martin Ameghule and his colleagues filed at the Federal High Court. And you know what? Principally, that was even when they realized that their action of the 11th was likely to cost them their seat. They quickly ran to the Federal High Court in Abuja to say, hey, please, court, tell INEC, tell the Rivers State House of Assembly not to declare our seats vacant. But it doesn't mean that if any other person approaches the court, there's the same issue. Now, the court for yesterday, it's not about asking the court to declare the seats vacant. No. Even the one by CN Wale, Oko Jumbo wasn't asking the court to declare the seats vacant. Even when the guest in studio read out those prayers of declaration, they didn't say declare the seats of those Martin Ameghule vacant. You know why? Because those seats had already been declared vacant since the 13th of December. And Godwin, my senior, knows that. So the question before CN Wale wasn't to ask him to declare the seats of Martin Ameghule and others vacant. Chamberlain and Kyla, it's different for me to tell you that, look, Mr. A's seat had been declared vacant yesterday by another person, but he's holding on himself still today as a holder of that seat that was declared vacant. And
but Mr. Kine, what does it then mean? What does it mean? Because Mr. Rufus was talking about that, why the court says return to status quo antebellum.
Very good.
Oh, I will explain that. Thank you, Chamberlain. Antebellum cannot also be imported from another matter into another matter. It's not also a blanket issue. The question of antebellum will be with respect to the particular subject and the parties before the court. Now, let me say for the one with respect to CN Wale, in my understanding, Oko Jumbo had been elected Speaker of the Rivers State House of Assembly. At the time he was elected, Martin Ameghule and his other friends had ceased to be members. So for him, and even for the Court of Appeal, antebellum before that, in that case, it cannot be antebellum in another case. Godwin is talking about antebellum in another case. No, for the conflict in the matter before CN Wale that got to the appeal is what was the situation before Oko Jumbo filed this suit? What was the situation before the contestation between Oko Jumbo and Martin Ameghule and others? It cannot be the contestation between me and my grandfather. It cannot be the contestation between maybe the civil society organizations and Martin Ameghule. The antebellum in that case may be different. The antebellum in the case of Victor Oko Jumbo and two others, yes, against Martin Amaewhule and 24 others cannot be the antebellum that Godwin is explaining. Okay. It's not. Even if the Court of Appeal ordered that antebellum should be maintained, it meant that what was the situation before Oko Jumbo filed?
We'll get him to respond quickly. But could you tell us, how many people were elected Oko Jumbo as Speaker?
The members of the University House of Assembly that were left. Chamberlain, you don't need to ask me. But if you ask me,
who elected them?
Unfortunately, in Rivers State. No, hold on, Chamberlain. Unfortunately, in Rivers State, and let me lay a foundation before I say that, the Constitution of the Federal Republic of Nigeria considered that in delineating constituencies in a state, no state house of assembly shall have less than, I think, 24 and not more than 40.
So can two people elect one person as Speaker?
Yes, they can. Even three, two can. And let me say why. I have a good opportunity that I have a senior there. And let me lay a foundation. It's not about having a senior, it's about the Constitution. The Constitution never, and even in Rivers, they will never envisage a situation where we will have this depletion of members. It has never happened anywhere in the world. Mark me, no legislature anywhere in the world that as much as almost the entire members of the House cross-carpeted. Okay. So it's a strange situation. We were left with 3 members, except anybody who is arguing that Martin Amaewhule didn't leave. They are the ones that will talk about 3 members. Okay. Those who are arguing that as they left, they lost their seat. You will not mind whether there are 3 members. And you know what? Sorry, Chamberlain. When they depleted to 3, it was disturbing to even the remaining members. That was why when they, to 4 rather, when they quickly elected Etisne, he quickly notified INEC to do the needful to conduct elections to fill those vacant positions. So at that point, the members of the House of Assembly that were left were 4. They elected the Speaker. After the other one,
if I heard you right, you say 2 of those people elected Oko Jumbo as Speaker. That's what you're saying?
Can.
Okay.
Yes, they can.
That's his answer.
Well,
what do you think?
For the public, and this is quite pathetic because lawyers are primarily the gatekeepers of justice, and they hold a higher retainer to justice, much more higher than that to their clients. And so in positions we take, particularly on a public platform such as this, we should consider justice. I feel a sense of revulsion for what is clearly a constitutional heresy by my learned friend saying that in a house, 3 members form the quorum and they can elect the Speaker among themselves. I'm not sure he has adverted to Section 96 of the Constitution, which provides that the quorum of a House of Assembly shall be 1/3 of all the members of the House. And we have a 32-member House of Assembly. What is 1/3 of 32? That is what we are talking about here. That 1/3 is what he has reduced to 3. Even by the most bizarre mathematical principle, you cannot come to the conclusion that 3 is 1/3 of 32. That is what Section 96 has said.
Was there supposed to have been a vacuum?
No, there should be no vacuum. If there's a vacuum, there's a process for filling it.
So what's the right thing that should have been done in that circumstance?
The right thing that should have been done is already being done until the court will decide the matter of the status of the Right Honorable Martin Amaewhule and his other colleagues. It's before the courts. It is not within the
No, but in fairness, there have been several judgments.
No, hold on. The courts do not say that once you defect, Ekine and others who feel like him should go and physically carry out of the house. That would be anarchy. In Abegunde and the Ondo House Assembly, the matter ran through the entire gamut of the hierarchy of the court and went to the Supreme Court. They were still in the house. So until the apex court determines the issue of the propriety or otherwise of the defection that he's talking about, they are members of the house. And so you cannot bypass them and use 3. It's an assault to the intelligence of Rivers people that in a house comprising 32 members, we have lawyers who justify the fact that 3 persons can pretend to be making laws for Rivers State. 3. Let us even assume that all the other members have simply resigned from the house, and we now have 3. Chamberlain, will you consider that 3 members will make law?
So it means that at that point there would have been no Rivers State House of Assembly.
No, there would be a way. There is a process for filling the vacancies.
But the process, assuming the process takes what? 1 month?
The process, months? The law is there. The law may be silent, but it still speaks. Yes, assuming that the 32 members, because what you do not know is that we have 23 local government areas in Rivers State. I'm from one of the local government areas. I do not have any of my lawmakers among the 3. So who makes law for me in the kangaroo 3-man member you're talking about here in the house? 23 local government areas. I'm from one of them. 3 will make law, and I'm not involved. The other 20 LGAs, who represent them? That is the logic. You do not have to be a lawyer to understand the falsity of this.
So what's your point? What should have been done? Assuming
it is already being done.
Which is what? The court cases?
Martin Amehule is the speaker. Yes, he has quoted references. He has made references to the fact that they have defected. But until the court finally determines whether the defection is proper or not, you cannot physically go and carry them out of the house. They are members of the house.
In other words,
and the Court of Appeal has said, we return to status quo ante bellum.
No, before that decision, in other words, there would have been no decision being taken by the Rivers State House of Assembly up until the matters are determined. That's your point.
I will say hypothetically, assuming that 33 out of the 32 members of the House, now Martin Amehule and the other 26 have resigned from the House, and they are no longer members of that House. And we are now left with 3. I ask you, look at Nigerians and answer Nigerians. Can 3 members make law for 32 members legislature? Can 3 members, 1 from Opobonkoro, 1 from Ahoda East, the other one from Boni, make laws for 23 LGAs? What are the 20 LGAs, including my own LGA? You don't need to be a lawyer to see how offensive this is.
Mr. Kine.
And for one of them to arrogate to himself.
Okay.
The
rank of because he laid the foundation before that. So let's see what he thinks.
The foundation he laid evaded all of these issues.
Mr. Kine.
Yes, Chamberlain. I wouldn't imagine that I would come for this discussion and I wouldn't read the relevant sections. Yes, with respect to quorum, to all members, and I would ask too, rhetorically, no, I don't expect my senior to answer. In a classroom or in a school where there are 5 members, and then 3 were expelled. 3 were expelled. They were no longer students of that school. 2 will be left. If they are called upon anywhere where that school is, those 2 will go and represent them, even if it is a decree that all schools shall have 5 pupils, but 2 have died, or they have been expelled, or they have left. So the situation in Rivers State, I agree and I sympathize with all of us that we never envisage, nobody plans to have this situation of having only 3 members. Now, this question of quorum is this. When you say quorum of all members, it is members, not quorum of non-members. So if you have 31 members at the time, because 1 had died, then it remains 31. And then out of the 31, you have 27 of them who, by law, I don't mind whatever discretion anybody will express. I hold on to the Constitution. And I say that the Constitution didn't provide that it is a court that will come and declare a seat vacant. I challenge anyone to read section 109. All of the paragraphs under subsection 1, to activate it, it is subsection 2. It didn't say the court would declare the seat vacant. No court declares any seat vacant by our law. It's not like somebody made an illustration this morning. If a governor, for any reason, does not probably, a governor dies, automatically a deputy governor is sworn in. You don't need a court to come and say that. The same to a president. That's why the Constitution for the legislature, that in the event that this happens, you don't need a court. So the 3 members are the only members that Section 96 was referring to. And what is 1/3 or 2/3 or any fraction that is required if all of them are present in a sitting? So that's why I made this submission, and I'm also waiting for the Supreme Court to decide it. Some of us are putting this argument until the Supreme Court decides it, not Godwin.
Talk to this, if you will. If you say that you don't need a court to decide some of these things, and you challenge them to raise Section 109, but what is the procedure? Is it not the Speaker that will declare those seats vacant?
It's the Speaker.
So in this case, which Speaker was to declare what vacant?
Excellent, Chamberlain. Look at what happened. It is important to understand the trajectory before you even... Now, number 1 is, when Martin Amehule read these letters, let us assume in the first instance that Martin Amehule never also defected. Then you would have had a situation where 1 or 2 defected. He will decide to either declare, or as we have in the National Assembly in some cases, the presiding officer would hold on, especially when the defection is in his favor. This is what politicians do in our country. Then he may be mandated by an order of court to do so. But in this case, in Rivers State, all 26, including Martin Amehule, the Speaker, left. So we had a situation where we didn't have a Speaker. So when the remaining members reconvened, this is the reality and the truth in Rivers State. When the 4 of them reconvened, they elected a Speaker pursuant to Section 92. And then when they elected the speaker needs to do that needful thing, that constitutional thing.
Before Mr. Godwin comes in,
there's a point of correction here that I remember.
You will, but could you tell us just briefly, Mr. Keenan, before he comes in, what is the current status of Mr. Edison here?
Excellent. So that what happened after he became speaker. Remember, he later, about 31st of December, resigned. So imagine again, too, when Edison here resigned, the number of members depleted further by one. So and became 3 members left.
Has anybody...
So the 3 members reconvened later and elected another speaker.
But if you say he's resigned, but we know the process of resignation as a member of the House of Assembly, State Assembly.
Yes.
Have those processes been fulfilled? Has the seat been declared vacant? Has INEC even recognized his resignation?
Yes, excellent. You know what? And as a lawyer, I'd also had a question about the resignation of Edison again. But you know what? You can't compel a person, even before the recognition of confirmation by INEC, you can't compel a person to be a member of association or a member of the legislature.
Let Mr. Rufus come.
He has resigned. His resignation, I agree that they have some procedural question. But he's no longer a member of the House.
There's a point of correction on fact here that I need to make so that the error does not germinate into the psyche of the public and they will take it as true. It is that there is not one single case in this country, and I challenge my learned friend to show it. There's not one single case of defection, either at the State House of Assembly, in the 36 states, or National Assembly, where the defectors simply carried their book and their documents and vacated and left. They had remained on seat until the matter became a litigation. Onto the Supreme Court, all. I asked him on air, let him mention one case at the State Assembly of any of the Houses of Assembly or the National Assembly where a member or members have defected and then all of them just packed their things and left. All of them have remained until the matter went into the realm of adjudication by the court. That is what happened in Abegunde, which is what is the latest authority on this, because that was a case of a full panel of civil justices of the Supreme Court. And the judgment was delivered by the then CJN, Mahmoud Mohammed. So it cannot be that by mere wishful thinking, because Ahmed will, according to him, and the others have resigned, so quickly they will go and physically take them out of the House. They must await the judicial process to set in. That is what we're talking about. 2, we talk about resignation by Edison and the others. The truth of the matter is that there was no such resignation. What has happened was that the 3 of them were suspended by the House prior to all this conflict. The 3 of them were suspended by the House of Assembly. So they ceased to be members of that House.
But Mr. Hill himself put up a letter saying
it was subsequently that he resigned to take up executive appointment as Chief of Staff. So he was resigning when he had previously resigned from the House. That is a fact that my learned friend knows.
So in other words...
So this trip imposed...
Does that mean the resignation is not valid?
No. He's already under resignation from the House. A man who has been suspended rather from the House. He's at liberty to go and do whatever he wants to do.
You were challenging him to tell you which law, which case has anybody defected that they end up in litigation.
Yes.
Now, if you say he's already under suspension, are you not remembering, too, that even when Senator Alain Dume was suspended, the court also decided that you cannot. Senator Dino Melaya to the same scenario.
Exactly.
So, how come you're citing that case?
No, he didn't go to court.
No, but you're citing his suspension as though it were valid.
I won't fall into this booby trap now.
Are there not cases already saying
they are not related?
You cannot suspend someone who is validly elected?
He has not challenged it. That's what I'm saying. He didn't challenge his suspension. He rather resigned.
You must challenge
an executive appointment.
So wait, you must challenge it, even though the law, there are precedents that says you cannot suspend certain persons if they have
the law says you cannot suspend, and you have been suspended, then you have the refuge to go to court to challenge it. He didn't go to court. Chamberlain, he didn't go to court. He rather purportedly resigned to take up an executive appointment.
Even if the person knows that there are court decisions, just a minute, because people are listening to you as a senior lawyer, just a minute.
The suspension is hanging over his head before he resigned.
Even if the Rivers State Speaker know that, look, there are cases that have been there that you cannot suspend a member.
Yes.
They can still go ahead and do it, expecting you to go to court.
You don't understand, Chamberlain.
Is that the way it works?
The law says you cannot suspend a member. That would be absolute. But that's not so. There are circumstances that you will warrant that you be suspended. To say otherwise, in absolute terms, is to fetter the discretion and the powers of the House as a distinct arm of government.
What are the circumstances?
There are circumstances when you breach the privilege of the legislature under the Legislative House's Privileges Act, when you conduct yourself in an indecorous and uncivil manner, and then you set yourself against the authority of the leadership of the House.
Indecorous and uncivil manner? Is that a violation of the law?
Yes, of course, that's a violation of the law. Like here,
isn't that a subjective term?
The House has its rules. The House has its rules. If you persistently disobey and violate the provisions of the rules, the House will say no. The court says we cannot discipline anybody. Remain. No. The legislature is a different arm of government. If they take action that the court consider to be unconstitutional, the court will come in. And the court comes in not on its own, going about saying that, look, I have seen you do this, let me arrest you. Somebody has to go to court. When this thing was suspended by the House, it was within his right, constitutional right, to have gone to court to challenge the suspension. He did not do it. But that doesn't take away the fact that he was suspended as a historical fact. But the truth of the matter now, which my learned friend has not adverted to, is that on his own, willy-nilly, he subsequently resigned to take up an executive position.
Okay, let him respond to that directly. Mr. Kine, go ahead.
Yeah, Chamberlain, please. Let me also pose another rhetorical question to the former head of service in Rivers State, and I ask this question. If he suspended a civil servant in Rivers State, will that civil servant be taken to have been dismissed or sacked from the public service or civil servant? The question is no. The answer to that is no.
Allow me to answer.
That
no, just
a member of the House of Assembly...
Just hold on. Let me finish. Hold on. Go ahead, Mr. Kine.
Yes. Suspension is not... I'm not even going to the angle of the decisions of the court that you have no right to suspend a democratically elected legislator who was elected to represent the constituency. Then you gather in the House, perhaps maybe you have one dissatisfaction or the other, or even a rule of the House that was made subject to the Constitution, then you suspend. I'm not going there. But I'm saying, assuming, without considering that there's even a justification for suspension, if you suspend 3 members from a 10-member House of Assembly, those 3 members, I would want to agree, and I know you will agree, remain members of that House of Assembly. Howbeit, they are on suspension, right? Then the remaining 7 die on a plane crash. Is that House of Assembly not having members? By some faith, those 3 members can come back if that House of Assembly is called to answer. To say, look, at least we are still here and alive to represent that House of Assembly. And whatever that is legitimately required to be done by that House of Assembly, they can do it. So let me assume, without conceding, that the suspension, purported suspension, was subsisting before Martin Ameghule and his other colleagues defected. And whether my colleague likes it or not, it is only in this country, and that's what the politicians are doing. Even when you know that the law is extant, and especially in this case, the Constitution, he said, let us do it, let them go to court. They said it during the election. If I let us manipulate the election, if you are dissatisfied, go to court. What kind of society, what kind of democracy is that? You know that if you defect, if I were a member of House of Assembly, and I prepare to defect, even if somebody told me to do so, the day I am accepting to that defection, I will go to my house. Why can't people be responsible? And then we are dragging Rivers State in this embarrassing manner. And then we say, oh, they are right. They are challenging their defection. They are the ones that first ran to Abuja. Because they knew that their defection will cost them their seats, even before any other action was instituted. The first people that instituted action, just about 2-3 days after, is Martin Ameghule and his colleagues. And they went to Federal High Court Abuja because they were afraid that they would be declared vacant. And they said, please don't declare vacant. Check that suit. Martin Ameghule and others against INEC, and I think PDP, Rivers State House of Assembly, and even the security agents. He
hasn't answered the question.
What are we talking about in this state?
One example in this country where those who defected just pack their things and leave without the intervention of the court at the end of the day. He learned that is this fact. He gave an analogy through what he call a rhetorical question. I will answer that question. He said, if as head of service, I suspended a civil servant without amount to dismissal, I mean, it will be a misnomer. And the misuse of language to equate suspension with dismissal. And there is a process in the service for disciplining an officer. So if you're on suspension, you remain suspended.
But you're not dismissed.
You're not dismissed. We are
You're saying there's the same thing that it's the point he was trying to make about the member of the House of Assembly.
Don't join this fray. If you join the fray,
no, that's what I'm asking you.
The doors will rob you.
No, because you're not considering what I'm considering. I'm considering
I'm answering him.
No,
you don't interject when he's speaking.
No,
you interject when I do.
No, that's
Let me answer the question.
I can't allow that germinate.
No.
That's not correct.
No, that's
because
not
I do interject.
Please allow me. He gave an analogy, and I was trying to rebut that. You come in. Suspension is
I'm
not
a moderator.
synonymous.
I have to moderate. That's what I do.
Suspension, even in its most simplistic term, cannot be synonymous with dismissal. Here, the members of the House were suspended properly. They have not been dismissed. They have not been expelled from the House. In fact, expulsion would be the proper synonym for dismissal within the context of the House. They were suspended.
So if you're suspended as a member of the House,
yes,
you're still a member.
Of course, you are still a member.
To be a member.
No. That's what I'm saying. They have been suspended, but they cannot enjoy the liberty of returning without being recalled by the due process of the House that suspended them. And all of a sudden, came to arrogate themselves with the position they are now posturing. That
Gentlemen,
one is a speaker, the other one is this.
Can people watching
to the sensibilities of our people?
Can people watching now not say that the courts and the lawyers seem to be complicating this simple matter?
That's what I'm saying. I expect that by now, my learned friend and all who think like him should be advised and say, look, gentlemen, the courts are there. That's what I'm saying. We advise our people to remain in status quo antebellum until the court decides these matters. What the proposition is making is a tacit invitation to anarchy to say, look, go and take them out of the House. They don't wait. You don't need to wait for the court to decide. A lawyer should be the last person to reason that way. In Omotosho, Justice Omotosho, in this same case at the Federal High Court, has already ruled that Edison was never a speaker.
Mr. Kine.
So these are the things. And we have this proliferation of cases in court.
Okay.
And then a high court yesterday will go and return the chief judge, return the House.
Briefly before we wrap up, Mr. Kine.
Most unconstitutional.
Hello, Chamberlain. Sorry, I didn't get that.
Go ahead and give us your closing thoughts. I did ask, are the lawyers and judges not complicating this matter?
Yes. No, lawyers are not, except those who are politicians. I am not one. But for Chamberlain and Kayla, let me say, whether we argue back and forth, and then whether politicians want to perpetuate their positions, the bottom line is we are greater as Rivers people together. And again, we have a greater proportion of Rivers people who are not involved in all of this. Let me give a little bit of the statistics. In the matter in the Rivers State House of Assembly, there are only about 32 members that were originally elected. One died, one has resigned, so we have probably only about 30, giving us this headache. Then number two, even those who would want to benefit from them, I think that we all have to remember that the greater proportion of the population of Rivers people are not in this, and we're expecting good governance, peace, and stability in this state. And again, we profess to be a society.
I'm afraid we're out of time. We need to go.
That's my closing remark. Thank you.
You're entitled to wrap up within the time, but you already wrapped up before we went to him.
My wrap up would be that lawyers.
Mr. Rufus Godwin's legal practitioner,
angels of justice,
former head of civil service, Rivers State House of Assembly, as well as Mr. Henry Ekine, National Legal Advisor, Committee for the Defense of Civil Human Rights at CDHR. We have to thank both of you for coming on, even though many are a little more confused than getting a solution to this matter. But Business Morning on Sunrise really comes up now.